Hi, Jack Ryan here, and welcome to another session of Legal and Liability Risk Management Institute's roll call training. Today we're going to talk about use of force, and in order to talk about use of force, we have to talk about kind of the foundation cases. Remember that one of the foundation cases, although its vitality is not as strong as it used to be, is Tennessee versus Garner, and we've all heard of that case. Goes back to 1974, Memphis, Tennessee, and officers were called to a residential burglary. It was nighttime. A neighbor meets them outside and tells them that the neighbor is away on vacation. Somebody's in the neighbor's house, and one officer goes back to the car. You know, probably most of us today wouldn't remember this. Unfortunately, I do. It was at a time when we didn't have portable radios. And so one goes back to the car to call for backup, while the second officer actually goes to the rear of the house and kind of L's off on the corner of the house. While this is going on, a young man runs out the back door of the house and crouches by the fence. The officer, Hyman, yells, "Stop, police." When he does, the young man, 15-year-old Garner, starts to jump the fence to run. The officer fires a single shot and kills young Mr. Garner. Turns out that Garner stole a purse with $10 in it or some small amount like that from the house. Now, remember, back in 1974, the state of the law, pretty much in the whole country, was that officers could shoot any fleeing felon, and certainly Garner was a fleeing felon. What went to the United States Supreme Court, and it went there in 1985, was a challenge to the Tennessee statute that allowed officers to shoot any fleeing felon. And this is a case that placed limits on shooting fleeing felons. The case didn't go as far as even we train it. Essentially, the Supreme Court said, hey, look, lots of things are felonies today, and they did a survey of law enforcement agencies around the country. They said, hey, most agencies don't even allow officers to shoot just any fleeing felon anymore. And so the prevent escape provision under Garner became limited. And it became limited to that an officer could use deadly force to prevent escape only when the officer had probable cause to believe that the subject had committed a violent felony involving the infliction or threatened infliction of serious bodily harm or death. Now, I will tell you that even today, most agencies in the country, and even us with our clients, we write policies that are a little more restrictive than that, because we go a little bit beyond the rule of law and we say, and by the subject's escape, they pose an imminent or immediate threat to someone else out there. So again, that's Garner. The other major case, and there's been a few new cases, but we're going to focus on two today. The other major case was Graham versus Connor. A little bit of background. Mr. Graham worked for the North Carolina Department of Transportation, lived in Charlotte, happened to be a diabetic. He's riding with his buddy by the name of Barry, and actually pulls into a gas station, and because he's having a diabetic attack and he needs some sugar, something with sugar in it. He actually goes into the store and almost just as quickly exits because he sees a long line in the store, jumps back in the car with Mr. Berry, points to his girlfriend's house, and Mr. Berry's going to take him to his girlfriend's house so that he can get some kind of sugar so that he can overcome this attack. Hey, Mr. Graham says that when he went into the store, he saw an officer, turns out to be Officer Connor. He saw an officer parked in the parking lot talking to someone, but he didn't pay any attention to him. Officer Connor, and again, I think it's a great stop, sees a guy jump out of the car, run into the store, run out almost just as quickly. He thinks something has occurred in the store, so he goes after Mr. Berry's car, pulls the car over, and actually pulls up and gets out, walks up, says to Mr. Berry, what's going on? What's the matter? And according to Mr. Graham in testimony at the initial trial in this case, Mr. Graham says that Berry's response was, hey, he's having a sugar reaction. The officer said, well, you're going to have to sit here for a period of time till we figure out what happened at the store. And I'll tell you what the officer does. He's out of his car. He heads back to his car. And there's no question, Mr. Graham will later testify at the initial trial. He says, look, at that point I really don't remember for a period of time what was going on. He said, I remember thinking, I'm not going to sit here and die in this car from this diabetic attack. Bottom line is Graham, and Graham doesn't remember this, but Graham gets out of the car, he runs 2 revolutions around the car, sits down on the curb and passes out for a brief period of time. Hey, other officers respond to the scene. Connor has called for backup. They arrive at the scene, and hey, they're on the scene, and now the story really goes in 2 different directions. The officers would indicate that Mr. Graham started to fight with them. Mr. Graham tells a very different story. He says that he wakes up, he's handcuffed, he's brought to the front of the police car. At some point, officers manhandle him, throw him to the ground. Bottom line is Graham ends up with a broken foot, some small injury to his face, some cuts on his hands, I think probably from the handcuffs. And the case goes to a federal trial. Well, the federal trial judge instructed the jury and used the Johnson v. Glick standard that some of you may remember, which was a subjective standard on use of force. Hey, the case that goes to the Supreme Court doesn't decide whether or not Graham's rights were violated. But what the Supreme Court does is they say, hey, look, when we're talking about use of force on the street, arresting free citizens, we're talking about a Fourth Amendment analysis, and the analysis is objective reasonableness. And the court says, hey, here's how you figure out if an officer's conduct was objectively reasonable. First, you look at how serious was the offense the officer suspected at the time. Second, you look at whether there was a physical threat to the officer or anybody else. And again, the court says an immediate or imminent. I think the quote is immediate, physical threat. And third is whether the subject was actively resisting or attempting to evade arrest by flight. I'll tell you that I think there's an easy way to think about this. Remember that the greater the government interest, the greater the government power. Hey, we have various tools that officers have on their tool belt, right? Some don't hurt at all. For example, officer presence. Some hurt a lot. Shooting someone. When you have a low government interest, you're not justified in hurting somebody real bad. And again, maybe I'm making this too simplistic, but it really does work this way. The greater the government interest, the greater the government power. If the government interest is very high, then you can even use deadly force. So again, this is the way the Fourth Amendment scale really works across the board. You know, I'd like to think about it this way and use some examples. And some of you may have heard me use this example in live training. But let's suppose you were to get a call for a shoplifter at the local Walmart. Hey, you respond to that call, you arrive on scene, and all of a sudden you see that shoplifter running across the parking lot. Hey, he's running, he's not stopping, the security guard is chasing him. It's very clear to you that he's the shoplifter. Oh, shoplifted a candy bar, you know. Hey, how serious is the crime? How much force can you use to make that apprehension? How important is the government interest? It really is that simple. What kind of physical threat is the person? He's a shoplifter who just shoplifted a candy bar. Does he pose an immediate physical threat to anybody as he's trying to flee? Clearly, he's actively resisting by running away. Clearly, he's trying to evade arrest. So certainly we do have that factor. But again, the government interest is low, so the use of force has to be proportional to that, right? And I'll mention proportionality a little more in a minute. Hey, the physical threat. Again, how much of a physical threat is he? Let's change the factors. Let's suppose instead you were to respond to a violent molestation of a child, the rape of a child at a local daycare center by a stranger who had somehow invaded the facility, and you get there and that subject is running from the scene, and it is clear, there's no question that it's the subject responsible. Daycare workers, that's him. In fact, they're trying to hold him back. How important is the government interest in that one to make sure that that individual doesn't get away, right? And is he a continuing physical threat to the community above and beyond the seriousness of the offense? So again, we can look at different crimes, the nature of the crime, and look at, how serious is the crime to determine what the government interest is, to determine what level of force will be justified in order to make the apprehension. Hey, as we deal with physical threat, we're not always just dealing with physical threat to the officer, we're also dealing with physical threat to anyone else who may be present at the time. So again, another significant issue in this case. And again, we can make a similar comparison. Suppose we have two domestic cases, fairly identical, they're in public. One is an 86-year-old man who, for some reason, slapped his wife across the face. He's little, he's kind of frail, and hey, mandatory arrest on domestic in most states. We go to arrest him, and he says, "You're not going to take me alive," Hey, let's compare that to the 24-year-old football player who's 6'8", 260 pounds, but of solid muscle, and he has done the same slap of the girlfriend's face, and we say to him, "Sir, you're going to have to come with us," and he says, "You better call for help." The physical threat is dramatically different in each of those cases, and because of that, so is the level of force that an officer could respond with. Hey, active resistance is something that we have to be certainly careful of because, again, let's put the First Circuit and the Ninth Circuit aside for a second. Most of the taser training says you don't use on passive resistors, so you use only on active resistors. So we have to look at how we define active resistance as well in these cases. Hey, I do want to mention force continuums, and probably some of you are still training with a force continuum or using some force continuum. And, I'm a firm believer and of the opinion that although they may have some use in training, we really should be focused both from a training and policy perspective on the gram factors. The reason for that is this, and I'll tell you that I have reviewed force continuums from around the country, all different types of models, the reactive control model, the situational force model, the linear model, the pyramid model, you name it, I've seen it. And I will tell you that in doing all the cases that I do, most officers are unable to explain the way the continuum works. So that's problem one. Problem two is it doesn't take into account all the variables. And I would just ask you to think about this. Sometimes I'll be doing a live training in class, and I'll take the smallest officer, that officer who's 5'5", 135 pounds. And I'll have them stand up next to the officer who's 6'4", 270, like a rock. And, I'll ask the officers in the program, put these two officers in an identical situation, which one gets to use more force? And it's an easy one. It's a no-brainer, right? The little guy gets to use more force. Now, under gram, that's easy to understand because the physical threat changes based on officer, offender, size, and ability. That's easy, right? Not so easy on the most of our force continuums that don't take into account the variations between officers. So I'd suggest to you that you go back and look at yours and see if it does. My suggestion to you is that in most cases, we're better off using the gram factors and using that government interest scale to make a determination. Before we leave that, I want to mention something else. Officers need to understand that if they are making a reasonable suspicion-based stop, they do have some power to cause that detention, right? And they can use force to cause that detention. they cannot use the same degree of force that they would if they had probable cause to arrest. Now, and I say that, it's a pretty simple proposition that the government interest is higher when we have probable cause to arrest than it is for a reasonable suspicion-based stop. In fact, there is some Supreme Court language that would suggest that an officer can use force to make a Terry stop. They can never use deadly force to make a Terry stop. So we have to keep in mind that that government interest is different as well. Hey, one of the things that I like to talk about is the concept of use of force itself. And most of you know this. I'm a big proponent of the term response to resistance as opposed to use of force. Now, there's some reasons for that, and probably the big reason is this. Officers use force in 0.5% to 3% of all contacts in the United States, and we don't use force very often. And the corollary of that, or the backbone of that, is the fact that most people we walk up to and say, "Sir, you're under arrest, ma'am, you're under arrest," they comply and they're arrested, and no force is necessary beyond, maybe an escort and handcuffing. That's it. Most of agencies don't even document that kind of stuff. So what does that tell us about when force is used is that we really don't use force. We're responding to a level of resistance that we don't normally face because most people automatically comply. Hey, another example I use is this, and I've used this even in front of juries. Imagine yourself driving to work, and you're going a little bit faster than the posted speed limit. All of a sudden, you see a marked police car. What do? What does the average person do? And I'll tell you that everybody slows down. Even you guys that are officers, that are deputies, you guys slow down. Hey, that's because all law-abiding citizens, and even most criminals, when they see the visual symbol of legal authority, they automatically comply their behavior to what's expected under the law without ever even being told what to do. So again, this is why, when we sit to document use of force, we ought to always start with officer presence. Because let's face it, officer presence is what really controls in most cases, and people respond to officer presence. Another example I use, I had a case where it started over a red Solo cup, and I actually, said to the jury, I used my speeding example, but then I used a second example, and I said, look, if you were an underage drinker, and I said, I don't know if any of you ever did that, but if you did, and you saw a police car pull up, what would you do with your red Solo cup? And I actually had two women on the jury actually do this with their hand and throw the cup over their shoulder. So I think it's important to understand that, in fact, most people respond to mere officer presence, and it's only when they fail to do what most people do that we have to respond to the level of resistance we face. Hey, I want to talk about proportionality for a minute. There's some new suggestions by the Police Executive Research Forum, not all of which I agree with, but proportionality is one of them. And I think that that's one that we ought to really consider. And again, there's some others as well. They make some good points on some things, some of the things that we're already doing. The reason why I think proportionality is important is this, is that it's very consistent with Graham's three-part test. Because how will we decide what's proportional? Well, we decide the seriousness of the offense and the government interest, right? The greater the offense, the higher the proportion of force we get to use to make the apprehension. The greater the physical threat, the higher the proportion we get to use to stop the physical threat. So I think proportionality has always been there. But the reason why I think it may be important that we start to train this as one of our kind of foundation principles is this. The Supreme Court last term decided a case, Kingsley versus Hendrickson. Now, this is a use of force case that occurred in a jail. And the jails were a little bit messed up because depending on the status of the prisoner would determine how the use of force was analyzed. So just to give you kind of the quick down and dirty, a person gets brought into the jail. In most circuits, they were Fourth Amendment until they went for arraignment. They go to arraignment, they don't make bail, they come back to the jail. Now they're, quote, a pretrial detainee. They've already been arraigned. They're 14th Amendment. Totally different analysis from the Fourth Amendment. And then they go to court, they get sentenced, they come back to the jail. Now they're sentenced prisoners and they're Eighth Amendment. Supreme Court basically eliminated the 14th Amendment and said, look, a person is a Fourth Amendment for purposes of use of force until they become a sentenced prisoner. In doing so, they set various things that may be a little bit different in the jail for purposes of force. For example, and again, it's a topic for another training, but one of the things they said is that, the safety and security of the jail is one of the factors you consider, and you give some deference to the correctional folks for maintaining the safety and security of the jails. Now, we don't necessarily have that issue on the street. One of the factors they did use, though, was proportionality. And they used that the use of force had to be proportional to the safety and security issue, to the threat issue, whatever it might be, in the jail. So it only makes sense if that was a Fourth Amendment analysis by the Supreme Court in a recent case that we would take that forward and use that language. Again, I think it's always been covered by Graham because we get to consider seriousness of offense, physical threat, the degree of active resistance, and any attempt to evade arrest by flight. Hey, we have some additional duties when we use force. What do I mean by that? Well, there's some duties. One, all of the courts recognize that there's a need to temper the force. What does that mean? Again, part of this is maybe one of these principles that PERF is putting out as a new principle. It's really not a new principle. We have always had an obligation that as the resistance de-escalates or as the resistance ends, we have to temper the force with it. So in other words, we might have been fighting the most dangerous guy in the world. It might have been highly threatening. But at the point that he starts to submit, then we have an obligation to back off on the use of force as well and de-escalate. Some other examples of tempering force, and we can put these really under two of our duties, but there's a case out of the 11th Circuit. I forget if it's Florida, Georgia, Alabama. But it's a case where officers at a jail pepper spray an individual who's acting up and running his mouth, and the court essentially has no problem at all with the use of pepper spray. They said, hey, the jail had to maintain security, they had to maintain the safety of the other prisoners, this guy was acting up, he was starting a problem, inciting people. What the court had a problem with, though, what the case that the court let go forward was, after this guy gets pepper sprayed, he's taken and put in a cell where there's no ability to decontaminate. So the court said, hey, the failure here is not with the use of force. That's not the issue. The issue is the failure to temper the force by allowing him to decontaminate. That really goes to one of our second duties, or our second duty as well. There is always a duty to provide medical care after we have used force. Now, I'll tell you the courts, there is a little bit of a split on this. Some say it has to be reasonable medical care under the Fourth Amendment. Some of our courts say we can't be deliberately indifferent to medical care. At the jail, once we get there, it's deliberate indifference to medical care. But the bottom line is there is this duty to render aid and to provide medical care. Hey, I'm going to give you an example here that I think is really, really important. We get a lot of cases where we've had the knockdown, drag-out fight with someone. For whatever reason. It could be the excited delirium type of case. It could be just the guy is fighting like a son of a gun and we just can't seem to get control of him. Bottom line is, we finally get the subject restrained. And I'll tell you, we see all these cases. I was reading a deposition last week where one of the officers says, hey, we are just trying to collect ourselves. And in the meantime, an officer stays on the subject's back, or maybe they simply leave the officer on his the subject on his stomach. The bottom line is, when we use force and we have this kind of fight with the subject, please get the person into what the courts are calling a rescue position right away. What is a rescue position? Rescue position is a position which facilitates breathing. Remember that a person on their stomach may not facilitate breathing, particularly when they're handcuffed behind their back. An officer on their back, at least arguably, doesn't facilitate breathing. And believe me, I know there's some experts out there who say that won't compromise breathing. I know that. That's for the courts to worry about. What we have to do as officers is we have to get off them right away and then either turn them on their side or in a seated upright position. Those are the positions that have been identified as positions that facilitate breathing. So we're going to condition ourselves to do that. Same thing with other medical care. We have even shooting cases, where it's alleged that instead of getting down on the ground, putting on latex gloves, putting pressure on the wounds, officers are standing around. In fact, I've got a couple of cases where it's alleged, I don't believe it to be true, but it's alleged the officers are actually high-fiving each other following the shooting. So we want to make sure that the first reaction is to provide medical care to an individual you use force on. Hey, I'm going to suggest something to you, and you might think this is crazy, but trainers are always talking about condition response. And even officers who have been involved in critical events will often come back and say, hey, look, I just reverted back to my training. I did exactly what I was trained to do, I didn't even think about it. And I do believe that we can condition training. So, hey, I want my firearms instructors to think about this. When we go out to the range, and we shoot from various stages, right? We shoot from the 7-yard line and, all the way back to the 25-yard line, various positions, under time, weak hand, strong hand, all kinds of stuff, depending on your state qualification course. When that last shot is fired and the line is safe, we always say, hey, break your tunnel vision, make sure there's no other threat. And we certainly want to do that. Officers reholster, and then everybody wants to go check the target to make sure that they passed, right? Hey, let me ask you something. Could we possibly condition a response by, instead of allowing that happen, allow the training to keep going, and instead have officers don latex gloves, run up to the target, put it on the ground, and put pressure on the holes on that target? Might that condition a response? And I think that's maybe somebody is saying, Jack's crazy, he's really thinking out of the box on this one. But I got to tell you, as I talk to trainers, they don't think it's so crazy. It's a conditioned response, and we really have this secondary duty. So first duty, temper the force. Second duty, medical care. One of our other duties is a duty to intervene when we observe any kind of unconstitutional use of force. Hey, the cases are all over the map on this, right? But there are a couple of elements that have to be met. One, the officer has to be in a position to observe the unconstitutional use of force. And two, there has to be an opportunity to intervene in the unconstitutional use of force. So, hey, we see this come up, and I'll just give you an example case. I had a case, this goes back a number of years ago, out of New Mexico, I believe. And what happens is a guy actually shoots at some officers. Officers respond to a domestic. It's not even the house where the domestic occurred. There's some confusion as to the address because there's 4 different houses on the same address block. One is 39A, one's 39B, but the call comes over just as 39. So they're knocking on doors. And this man actually comes to a door with a shotgun. The officers retreat. He actually fires a shot. He'll later say he thought it was kids playing a prank, so that was who we were shooting at. So yeah, I guess, I don't know. At trial, he actually says that, and he thinks that somehow makes it better. Bottom line is, when the officers get him to drop the shotgun and get down to his knees, it's alleged that one of the officers runs up and slaps him upside the head, and with an expletive says, what are you doing? I've got kids at home, And the officer's upset, obviously, if it happened that way. Bottom line is all of those officers actually went to a trial and were defendants for failure to intervene in that officer's use of force that would be, under those circumstances, excessive, if it happened that way. I'll tell you that the jury found that there was no Fourth Amendment violation in that case. But bottom line is, the judge, when he finally heard the actual evidence, he kind of apologized to the officer. He said, I didn't understand this on the pretrial motions. My understanding of this chaotic scene was different. Now that I've heard the testimony, I recognize that the officer had no opportunity to intervene because it happened like that. Hey, I'll tell you that in most cases, a single shot, a single punch, a single baton strike is not going to be subject to a duty to intervene because the officer is not expected to have a crystal ball. However, if you have a case where there's multiple strikes, some of those strikes may fall under this duty to intervene. And an officer who fails to intervene has the same liability as the officer who commits the excessive force. There's kind of a funny case, I think it's out of Hialeah, Florida, if my memory serves me correctly, where this guy alleges that he's on the ground in a fetal position, he's covering his head, and he sees the same boot continue to strike him. And he says, look, it was only one of the two officers who was there. I don't know which one it was because I didn't look up because I was covering my head. The officer's lawyer takes the position, or both officers' lawyers, that since he can't identify which of the two officers it was, then neither one has liability. Because you would be essentially, arguably, his argument, the defense argument, is that you would be finding somebody guilty who didn't do it. Hey, what the court does, and I forget if it was a federal trial court, if it was the 11th Circuit, but what they say is, hey, look, bottom line is, one officer is guilty for actually committing the excessive force, the other one's guilty for failing to intervene. And they say it's the same liability. And they said, otherwise police officers who wanted to commit acts of excessive force could simply bring paper bags with them onto calls. The court actually says this. Bring paper bags with them onto calls and put them over the subject's head before they beat them. So again, we have this duty to intervene. Hey, I want to talk about some specific uses of force that come up in the cases. And I'd like to start with handcuffing. We see a lot of handcuffing cases, and to me, that's the easy one to avoid. We've got this covered in our policies for all of our clients, so take a look at the policies. But hey, handcuffing. We see two types of cases. Case type number one is the person complains that the handcuffs are too tight. Hey, if a person complains they're too tight, do me a favor. When it's safe to do so, not when it's not safe to do so, when it's safe to do so, check for fit and double lock. And certainly document that, okay? That will avoid most of those cases. Not in the middle of the fight, but when you've got a second officer there, when you've got a person who was compliant from the beginning and submitted to handcuffing, check for fit, double lock, and then put it in the police report, put it in the sheriff's office report, whatever incident report you fill out. Subject was arrested, handcuffed, check for fit, double locked. And again, if we make this the habit, we will avoid those cases. Hey, I will tell you this, that most of those cases on handcuffing, when they claim the too tightness, require two other elements. They do require that the person complained, and they do require that there is some physical injury, not just the pain of being handcuffed. As we move to more and more cases of both body cameras, cameras flipped around on the back seat in the police car, I think these cases become a little bit easier because we would be documenting whether the person actually complained or not. But again, something to think about. The other type of cases we get on handcuffing, and again, I guess I put this in two subcategories, if you will. First subcategory is vulnerable persons, right? And I guess the first example I would use is the elderly. There's a lot of elderly cases where the officer is left with no choice but to arrest an elderly person. Okay, who knows? Maybe it's a domestic mandatory arrest. So they're forced to arrest the elderly person. They say, hey, turn around and put your hands behind your back. And the person puts their hands behind their back, but this far apart. Officer says, oh, whoa, 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 you're going to move those hands closer together. That chain is only, this long. And the person says, that's the best I can do. And then the officer decides to help and pulls those hands together. I've seen some good officers do this, It defies common sense. Some of you may be looking at this and say, Jack, that defies common sense. But I've seen even some good officers do that. They pull those hands together, thinking that they're going to accomplish the handcuffing, and instead they break arms, they break bones, they dislocate shoulders because of all different, things that happen to elderly people. So we have to really consider that in these handcuffing cases, that some people may have vulnerabilities that are either stated or obvious that we should take into account. The other type are, the person that normally looks like the healthy, youth, and I say youth, I mean somebody over, in their late teens, early 20s, right through middle age, somebody who shouldn't have the kind of health issues that the elderly person has. And we go to handcuff them, and they tell us, there's a case out of Massachusetts, for example, the Aceto case. This woman gets picked up on a minor warrant, local police department. She says, look, I've got this injury from playing hockey. You can call my doctor if you like. She gets picked up during the daytime. Doctor's office is open. Officer says, no, let me handcuff you in the front. He does that. Takes her to the police station. He's doing the paperwork. It's going to be a change of shift. Different officer going to take her from the police station to the Sheriff's County Jail. What happens is that second officer demands that she put her hands behind her back. She gives the same explanation to him. She offers the doctor's number to him, but he insists that policy and training requires him to handcuff behind the back, and he forces her hand behind her back and causes her some significant injury. In that case, the court says, hey, look, she had a stated injury that you could have verified. You caused her further injury by handcuffing, and the court found that that was excessive under those particular facts. So we do see those kind of cases where a person has a stated or observable injury. Again, one of the things I would say to you is that that's a call that you have to make when the person, it's not obvious to you. That's a call that you have to make on an assessment of threat. We'd never want to tell you not to handcuff someone who was simply trying to get over on you by alleging, an injury or a disability of some sort. Hey, pepper spray. A few things come up with pepper spray that I do think are worth talking about. One, crowded and enclosed areas. Places with closed ventilation systems. We do see some cases where the secondary impact issue becomes important. One of the examples I use, it goes back a number of years now, but and some of you may have heard me use this before, but there's a case out of Chicago where an off-duty officer was working in a nightclub, and there was some kind of problem in the nightclub, and the officer ended up using pepper spray on one individual. Hey, bottom line, it's dark in the nightclub, the music's playing, all of a sudden people start choking, and they start rushing for the door, thinking that maybe gas has been introduced into the building, maybe even poisonous gas. Who knows what they were thinking. But 21 people were killed in the stampede. It only did not get greater attention because of something that happened just a few days later in my home state, where we had the Station nightclub fire and 100 people were killed in a nightclub. But the bottom line is, when you're in a crowded, enclosed area, the secondary impact of the pepper spray has to be a consideration. The other thing is closed ventilation systems, and some of you have probably seen this. Officer in the hospital emergency room. There's been a couple of cases like this. Officer got a prisoner, he's guarding him at the hospital. Prisoner starts acting up. Officer sprays the prisoner, and my goodness, the next thing you know, that pepper spray gets sucked into the heating, ventilation, air conditioning system, and before you know it, it's spread throughout the hospital, including the respiratory wing. And so we have to really be careful of that secondary impact in those kinds of cases. Something else that comes up, and we've seen this, and in fact I had an officer tell me this happened to him in training, something that some have identified as the hydraulic needle effect. We've got to remember that if we're using the stream, pepper spray stream, that stream comes out of that can under pressure. And just like Taser has warnings about use of their products, so does the pepper spray. And they say, hey, don't hold it too close to the eyes, because if you do, that stream will rip through the eyeball like a needle, giving it the name hydraulic needle effect. It wouldn't matter if it was water, it's the pressurized stream that causes the damage. I know of at least one case. I had an officer who is on light duty forever. He comes to training when I do live training, and he tells me that this happened to him during a training exercise, and he's blind in one eye as a result. So we want to be real careful about that, and we want to know the safe distances on the pepper spray. One more that comes up, and we see this in cases around the country, some of the courts are critical of pepper spray being used as a pain compliance tool. I tried this in court one time, and it didn't go over very well, but I was trying to explain the difference of various uses of force. And I talked about the infraorbital, and I said, it worked great on my kids at home. And I'll tell you, don't do that in court, because the jury looked at me like I was a child abuser, right? And but I was trying to give them a comparison, and the comparison is this. And I said, when I use pepper spray on my kids, it's different, because when I let go of the nose after they agree to do what I want, the pain goes away. But if I pepper spray them to get them to do what I want, and they do what I want, the pain stays. It's the gift that keeps on giving, essentially. Even sometimes, and you guys know this, that have been sprayed even with decontamination. So, while that's kind of a joke to kind of explain the differences, it's really what the courts are talking about in some of these pain compliance cases. They say, pepper spray really shouldn't be used as a pain compliance tool, because if the person complies after being sprayed, you can't stop the pain. See? So it's not like, a pain compliance tool where you can do that. So just bear in mind there is some criticism of that, and we should consider, if we're just looking for a pain compliance, we should probably consider something other than the pepper spray for that. Hey, let's mention a few things about Taser. I'm still seeing some policies out there. Remember, in October of 2009, Taser changed the targeting zone to lower center mass to avoid the chest shots. And it surprises me as I sometimes audit departments, or as I read depositions of officers, even from some of the bigger departments in the country that I work cases for, and the officers say that they were trained and the policy is still center mass. Remember that it's lower center mass. Remember that Taser now says the chance of death is not zero. Still highly unlikely. In fact, I think they say it's something less than 1 in 100,000. So highly, highly unlikely. But two possibilities in the death cases. And one is, a direct shot to the chest. There's a doctor who's done some testimony against Taser. He's also done some peer-reviewed medical studies, and he says that a direct shot to the chest where the probes are at locations above and below, I think on an angle is the way he says it, bottom line is that can cause ventricular fibrillation and cause immediate death. So that's possibility number one. I'll tell you that this doctor, his name's Douglas Zipes, is a smart man. He is the doctor who created or invented the mechanism that keeps people alive when they're waiting for a heart transplant. So he's not just some slouch. So I think we do have to pay attention to this stuff. The second type is where we have repeated deployments, and I will tell you that although the cases and the science seems to have always been limited to the probe mode cases where we have complete neuromuscular disruption, we see plaintiffs even making this argument now when it's multiple drive stunts. So keep that in mind, that if once we start getting multiples, and again, there's going to be some cases where that's going to be necessary. Don't get the wrong message from this. There's going to be cases where a person is going to need more than one deployment in order to protect the officer, particularly in cases where the office is out in the middle of nowhere, as many of you are by yourself. So that it may become necessary. I think the bigger point is, and that we want to make, is that if an officer accidentally hits someone in the chest, and again, it's possible because of the way everything's in movement, if the officer has to give the subject more than one deployment, those are the cases where we want EMTs to respond. We want the person checked out, because if they die some period of time later, we want to back up the fact that it wasn't caused by the taser because they were fully examined and everything was working properly. So we want to make sure that we do that, because we do see some of those cases. Hey, and again, it's subject to a different video training, a short one, part of our roll call training. But the Fourth Circuit has just decided this Armstrong case, and again, this is the ultimate decision is only applicable to the Fourth Circuit, but I think the rest of us have to pay attention to it. Essentially what happened in the Armstrong case is, and I'm going to give you a Reader's Digest version because I don't want to go through the whole roll call training again, but the officers respond to a situation where a person has walked out of the hospital. The person is going to be committed involuntarily because of mental health issues. When the officer finds this subject, the subject will not go back to the hospital. In fact, the subject actually wraps his arms and legs around a pole. He's kind of a big guy. Hey, as soon as the officers know that the commitment order is signed, a lieutenant orders that he be tased. He is tased. It doesn't work. The officers, 3 of them, lieutenant, sergeant, patrol officer, 2 hospital security guards, and maybe even the subject's sister, end up getting him off the pole, get him on the ground. There is some allegation in the case that they may have been stepping on his back and putting weight on his back. Bottom line, by the time they get him to the hospital, he dies. The Fourth Circuit has said that taser cannot be used, even in the drive-stun mode, because this is a drive-stun mode case, cannot be used unless there is an immediate danger to the officer, and there was no immediate danger in this case. This guy's hanging onto a pole. Said the officers waited less than 30 seconds to deploy the taser, so that becomes a bit of an issue in the case. And so, again, we've got to keep our eye on these cases. This particular case, we're dealing with a subject who is not being arrested, so they're going for mental health commitment. So the court takes issue with the fact that, we're harming somebody who we're trying to help from harming himself, that kind of argument. So we do have to take into account that there are mental health issues with some folks, and unless they pose a threat to someone else, that the better practice is to slow things down a bit on there. Hey, not seeing as many of the accident cases anymore. We had a lot of accident cases when officers particularly were wearing strong side carry with the taser. We're not seeing those anymore, and that's a good thing. But again, certainly something to be aware of, that there is muscle memory control, and we want to make sure that we have the right tool when we make a decision. Particularly, we don't want to have the gun in our hand when we're thinking about using the taser. Hey, just a little bit on deadly force. We use deadly force really in most of the cases as I see them, and I do a lot of cases. We have a lot of cases involving what I would call subjects who are emotionally disturbed, mentally impaired, or suicidal, and that sometimes provokes a response. And then we have a lot of shooting at car cases. So I'll just mention a couple of these quickly. The Supreme Court considered, and again, we've got a whole video training on this. It's one of our short roll call trainings, but and certainly all of our clients probably have seen it. Sheehan is the case where officers go to a house. It's a paranoid schizophrenic who they want to take out of this kind of halfway house where she's living and get her into a hospital because she's not taking her meds and she's acting up. She threatened to kill the social worker there. Officers are there merely for the transport. They enter into the room. She comes at the officers with a knife. They back out of the room. They call for additional resources. And ultimately, while the resources are actually arriving at the scene, maybe even on the sidewalk in front of this location, the officers decide to make a re-entry into the room with one officer providing lethal cover and one providing pepper spray. In my mind, it was a bad fact case because of all the training on things like containment and communication and all of that. She was by herself in the room. What was the need to go back in when you had all these resources coming? But the Supreme Court didn't see it that way. They said, hey, look, even if these officers violated training and policy, on dealing with the mentally ill, emotionally disturbed, a reasonable officer could have believed that they were in danger of serious bodily harm or death when she came toward them with the knife, and therefore they gave the officers qualified immunity in the case. So again, there is some another case, and that one's San Francisco County versus Sheehan, and I think it's important that we're at least aware of that. At the same time, look at a case like this Fourth Circuit case, which talks about dealing with the mentally ill, and understand we have a whole policy. We have training on dealing with people of diminished capacity, and where it's possible, where there's no immediate violence, and we have time, we ought to take the time to try to de-escalate that situation. This is a new case that just came out, and it's a case of great importance because it's the first time any circuit in the country has done what the Sixth Circuit did in this case, and it deals with the situation that law enforcement gets called to all of the time, the medical or mental health emergency. We know that in a couple of cases over the last year or so, and particularly Armstrong versus Village of Pinehurst in the Fourth Circuit, there's another one, Perrier in the 10th Circuit. The circuits have indicated that when we need to use force to help somebody, it's really different from the standpoint of the state interest as to how much force can be used. So that's really difficult for law enforcement because it kind of sets us up in a situation where we've got to distinguish the two different kinds of force. That's what the Sixth Circuit also did, but they came up with a different analysis for when we're using force in the medical or mental health emergency. The name of the case is Hill versus Miracle, and essentially what happens is poor Deputy Miracle, he gets called to a medical emergency. EMS is also there. EMS makes a determination, I think even before Miracle gets there, that Mr. Hill is in a diabetic emergency. I think his blood sugar was down to 38. It was extremely low. He needed to be treated. In fact, the court points out that people with low blood sugar, they can become combative. They can be, lose consciousness, extremely dangerous, and may even die if left untreated. Hey, the EMS folks are trying to put a IV in Mr. Miracle, Mr. Hill, and a Deputy Miracle arrives on the scene, and what happens with the first IV is Mr. Hill is so combative that he's actually able to rip out the IV, and now there's blood squirting. It's just a mess. The bottom line is Deputy Miracle then, at some point while Mr. Hill is fighting, he says, look, if you don't stop, if you don't calm down, I'm going to have to tase you to get you to stop. Mr. Hill continues to fight. Deputy Miracle takes the cartridge off and uses a drive stun to Mr. Miracle's thigh. Even the EMTs say that calms them down enough that they were able to start an IV with dextrose, and the EMT, I think his quote is, once he got the dextrose, he became not only an angel, but he began to apologize. In some sense, between the EMTs and Deputy Miracle, they probably saved Mr. Hill's life, but as often is the case in some of these, lawsuits, I call it no good deed goes unpunished. And that's essentially what happens here. Mr. Hill then brings a lawsuit against Deputy Miracle, arguing that excessive force, the taser, was used when he was in a medical emergency and problematic. Now, we know that we always apply the Graham principles, the three-part test from Graham versus Connor, to any use of force case. And that's essentially what the trial court does. They look at this in terms of Graham, and they say, three-factor test. How serious is the offense? And they correctly point out, there is no offense. We're trying to help this guy. We're not trying to arrest him. So there's no criminal offense committed here that the officers are trying to make an arrest. Is the subject actively resisting or attempting to evade arrest by flight? No, because we're not trying to arrest him. The court says, and I love this part of it, because the court says it's like sending a batter into the batter's box with 2 strikes against him. In other words, there's 2 strikes against the officer right out of the box on the Graham three-part test, because they're not making an arrest for a serious offense, or any offense for that matter, and Mr. Hill is not actively resisting or attempting to evade arrest by flight, because they're not planning on making an arrest. So the only thing you're left with is he is a physical threat to himself. That's what the issue is. The Sixth Circuit actually comes up with a new 3-part test. And the first part of the test is, and I'm going to paraphrase here, but I'll get it pretty close, and certainly you'll see, I'll quote it in the video so you can read it yourself. But the first question in these cases, in the Sixth Circuit at least, is the person in a medical emergency such that they cannot make a rational decision as to getting help for themselves? And 2, are they in a situation where they are a danger because they can't make this rational decision? Are they a danger to themselves or a danger to others? Question 2, so that's question 1. Irrational to the point that they can't make a decision and they're a danger to themselves or others because they can't make the right decision. Question 2 is, would some degree of force, and the court uses this word, would some degree of force ameliorate? Would it fix? Would it fix the situation? And if the answer to those first 2 is yes, so they can't make a rational choice, they're a danger to themselves, danger to others. Question 2 is a yes. Would some degree of force ameliorate or fix the situation? In this case, getting him controlled through the use of the taser in the drive stun mode. Did that get him controlled? Yes, it did. Was that a reasonable choice? That really goes to the third question. The third question is, hey, look, was the force that was used excessive? So it kind of flips it. Was it excessive in any way based on the circumstances the deputy faced? In this case, the court says yes. Mr. Hill was not in the right frame of mind because of his diabetic attack to make a rational decision, and as such, he was a danger to himself. He could die. 2, would some degree of force ameliorate or fix the situation? Yes. And was the force that the deputy chose, was it excessive? And the court says no, it was not. Ultimately, under the facts of this case, the court says, hey, this was a reasonable and objectively reasonable use of force based on this new 3-part test that they announced. The court does point out that they're not saying that the taser will be a valid tool in every single medical emergency, but it was valid in this one. It was objectively reasonable. So again, bottom line, if you work in the Sixth Circuit, we want to change policy. We want to add this to training. We want to give the officers this other analysis. Hey, in the case where it's a medical emergency, mental health emergency, think about these factors as opposed to the Graham factors. The other one, shooting at cars. Supreme Court over the last couple of years has had a couple of shooting at car cases. Plumoff, which I was involved in since it happened. Case out of West Memphis, Arkansas, where officers chased a car over into Memphis, Tennessee. Car spun out, and car actually came at Officer Vance Plumoff, and Officer Plumoff shot into the windshield. The car spun out of the hold, kind of a 3-way hold of police cars, and took off, and officers fired I think 12 more shots as it fled. And the Supreme Court said, look, this is a lot like Scott versus Harris. This Mr. Ricard, who was driving the car, posed a threat to the public by his high-speed flight, and an officer's attempt to stop a car that posed a threat to the public by high-speed flight does not violate the Fourth Amendment. I'd bear something in mind. Just because it doesn't violate the Fourth Amendment doesn't mean it doesn't violate state law. Remember, state law and your local policy can be more restrictive, and particularly as that car is driving away, it raises a real question if state law may not be more restrictive, or certainly your policies in those cases. So this is one that just because you can under the Fourth Amendment doesn't mean you should. Hey, overall, we are keeping our eye very closely on use of force. There is some suggestion that federally there should be some legislated guidelines that are more restrictive than what the Supreme Court has said on use of force. So we're going to be watching that closely for you. We're watching closely because some of that may relate to some of the suggestions that PERF has come out with. So again, we're keeping an eye on all that for you. At this point, we're going to stick with policies, and again, look at your own policies, but for our clients particularly, we're going to stick with policies that reflect the state of the law as it is right now on use of force. However, bear in mind that as best practices become either legislated or the trend, then we're certainly going to keep you updated on those as well. Hey, I want to take a minute and just thank you for joining us in these ongoing series. This particular one is our high-risk critical task series. These run a little bit longer, and as you know, you've been watching this for an hour or thereabouts. We think it's important to keep you updated on the high-risk critical tasks that, one, create most of the liability for you, but at the same time also impact your safety. And again, we will always try to give you the best practices that, one, help you avoid liability, but never compromise your safety.